Good afternoon, everybody. Thank you for attending today's presentation. This will be the last presentation for this segment of Landlord Service Provider Trainings. So thank you again for attending. Just a couple things, reminders, keep your microphones and cameras off during today's presentation. If you have questions, please put them in the chat and we will relay them to our presenter as we go along. And at the end, please take a few minutes to complete the survey. Please provide any feedback, topics, anything that you would like maybe presented on in the fall. Our next segment of presentations will begin the middle of September. So be on the lookout for that later in the summer. So with that, I will turn it over to Christina.
Good afternoon, everyone. Hopefully everyone is having a wonderful day. I have given this presentation for several years now, so hopefully you will find some information in it useful. And I premised this presentation by saying that these are the basics. Now, there might be some times where you're going to have a situation that is going to be extremely unique, and I would recommend, if any of that ever were to happen or you encounter such a situation, I would always advise to have you speak with an attorney who is familiar with eviction law so that you're not running afoul of what the laws in North Dakota are. So I think the questions will come at the end, so I'll just get started and we'll go from there. All right. So let's just cover the basics. When we talk about what is an eviction, that is the legal process to recover the possession of real estate when certain things happen. One being by a party by force, intimidation, fraud, or stealth has entered upon the prior actual possession of the real property of another and detains the same. Number two, a party after peaceably entering upon real property turns out by force, threats, or menacing conduct the party in possession. Number three, a party by force or by menaces and threats of violence unlawfully holds or keeps the possession of any real property, whether the possession was acquired peacefully or otherwise. A lessee in possession or by a subtenant holds over after the termination of a lease or expiration of the lessee's term or fails to pay rent for 3 days after the rent is due. Number four is the most common reason or basis for an eviction in the state of North Dakota. That one is generally the situation in which all of you are going to be facing. We'll explain how you get to that point, but for the most part, that is the one that is going to be most applicable in this situation. In addition to, there are a few other options or reasons or bases for eviction. Number five being a party continues in possession after a sale of the real property under mortgage execution order or judicial process, and after the expiration of the time fixed by law for redemption, or after the execution delivery of a deed, or after the cancellation and termination of any contract for deed, bond, or deed, or other instruments of future conveyance of real estate or equity in real estate. This one is most applicable in the event that there was a foreclosure, and after that foreclosure process is complete, the tenants do not vacate the property. That is where you're going to see number five being applicable. Number six, a party continues wrongfully in possession after a judgment in a partition or after a sale under an order or decree of the district court. Number seven, a lessee or a person on the premises with the lessee's consent acts in a manner that unreasonably disturbs other tenants' peaceful enjoyment of the premises. That is going to be probably number two or three in the reasons or the bases that you will find yourself having to move forward with an eviction. And number eight, the lessee violates a material term of the written lease agreement between the lessor and the lessee. That is also one of the major bases. So again, for the purpose of today, the three major bases that you will have is lack of payment for rent, there is a material breach of the lease, or you have a situation where someone is unreasonably disturbing other tenants. Those are the big three. So we'll talk about those as we go along here in just a second. So number one, again, being the failure to pay rent. This is the most common reason for eviction. As previously mentioned, that is when a lessee or in person or by a subtenant holds over after the termination of the lease or expiration of the lessee's term, or fails to pay rent for 3 days after rent is due. You want to make sure that prior to proceeding with any eviction for this reason, that you're checking the lease for penalties for failure to pay rent timely. Does your lease provide for late fees? Check the lease for any terms that may vary from the statute. For example, North Dakota has a statute that says that you have to give a 3-day notice. But if your lease says that you must give the tenant 30 days notice, you need to make sure that you're abiding by the terms of your lease. I did have a situation once where the lease provided for a 30-day notice, which we gave, and then the court also made us give another 3-day notice because that is what the statute required. So it's really important not to assume what your lease says. It's really important to read it. If there is no set provision that provides a specific amount of time, then you need to default to the Century Code, and that's the 3-day notice. But also just double check and make sure your lease doesn't have any particular provisions that require you to give additional notice other than the minimum requirement under North Dakota law. Disturbing the peace is the second one. That is where a lessee or a person upon the premises with the lessee's consent acts in a manner that unreasonably disturbs other tenants' peaceful enjoyment of the premises. The best case scenario is that you have a lease that provides for this, that is kind of like a catch-all provision that you can use in the event something like this were to happen. Most common examples of these are loud parties, loud music, fighting, erratic behavior. I did have one situation once where a tenant plugged on purpose the sinks in the kitchen and flooded the unit. That one was an interesting one. But if you are doing something in such a manner that unreasonably disrupts other people's possession of the premises, there could be a lot of different things. Smoking could also fall under this category as well, depending how bad it is. But these are just examples. If you've got someone that's coming home in the wee hours of the morning out of control and causing disruptions or disturbances where the police have to be called, that would likely qualify under this provision. The last one of the major three bases for evictions is the material breach of the lease. And that is where a lessee violates material term of the written lease agreement between the lessor and the lessee. You want to make sure that your lease contains some sort of provision with regard to this. Now, a good lease written in such a way will have specific provisions that require, if there's no pets allowed, it will say no pets. If there's no smoking, it will say no smoking. If there's some other restriction that's clearly identified and someone fails to adhere to that provision, then that is what is considered to be a material breach of the lease. For example, that can be smoking, pets, cleanliness, upkeep of the property, and of course, illegal activity on the property. If you know that or have reason to believe, or someone has come and said, hey, someone is selling drugs out of the apartment, that would be, if you can establish the evidentiary basis on that, that would be a material breach of the lease. If your lease provides that you are not to engage in any illegal activity on the property, that would be a material breach. If your lease says that the tenant must upkeep the property and make sure that it's cleanly at all times or in its common areas, and if that's not being done, that would be a breach of the lease. Of course, the biggest ones that we see on these are smoking being the major one, and then of course pets. We'll talk about service animals a little bit later, but obviously if they have pets in the unit and the lease provides that they're not allowed to have pets and it's not a service animal, that would be a breach of the lease. So let's talk about the process for the eviction. So the first step under North Dakota law is to serve what's called a notice to quit to the tenant. And in doing that, you need to identify what first what the violation is. So is that failure to pay rent? Is that disturbing the other tenants? Is that a material breach of the lease? The notice to quit needs to identify those particular violations. So you prepare that notice. Sometimes it's called a notice to quit. Sometimes we call it a notice of intent to evict and termination of lease. And the purpose of that document is to inform the tenant that there is a violation, that the landlord is proceeding with the eviction, and to inform the tenant that the lease is not being renewed. This notice must be personally served on the tenant. We recommend that you have a third party serve the notice and give to you a return of affidavit of service. This can either be done by a sheriff's office or a process server. And it's important that you do that because you don't want to have if there's an issue that comes up with regard to the issue of service of process, you don't want to have you or your people being called as a witness in that respect to address that issue. So it is much easier, it's much cleaner to have a third party do it. And specifically, when we talk about the summons, that is required to be served by a process server. So it also notifies the tenant that the tenant is to be instructed to vacate the property, and they must be given 3 days notice before the landlord can proceed with the eviction. If the tenant does not vacate within that 3 days, then the landlord is in a position where they can proceed forward with the summons and complaint. Step 2 then is the actual summons and complaint, and that is where you're seeking an official court order for removal of the tenant. The summons is the document that informs the tenant of the time and place of the hearing. And it's very specific in the statute when that summons must be served on the tenant. So you have to make sure that the summons is served no less than 3 days, but no more than 15 days prior to the summons being issued with the hearing date. So whether you have a process server do it or whether you have the sheriff's department do it, it's very important that they're familiar with those service requirements because that is set by statute. So if you have a sheriff's department or process server that you are typically using, they should be. But we did have a situation one time with the local sheriff's departments that didn't know that. And so they didn't understand that there was this specific time frame. So communicating that to your sheriff's office and or your process server will help you out in the long run. The complaint also outlines the reasons for the eviction. And the summons and the complaint must be personally served upon the tenant. If the tenant cannot be found, the documents can be posted after service has been attempted at least once between the hours of 6 p.m. and 10 p.m. And this is set by statute. So there is no maneuvering around this. And again, this is something that your process server or your sheriff's department should be well informed about, but this is required by statute. And again, having a third party serve that summons a complaint, sheriff's office and third party process server. In fact, the statute requires a third party. So it's really important that you have that done by someone else. And then your sheriff's department or your process server is going to give you an affidavit of service or an affidavit of posting. That posting is an affidavit that gets signed in the event that someone cannot be located. They post it conspicuously right on the premises. That is, again, if in the event somebody can't be located. And the reason why the statute is allowing us to do that is because, of course, you have some people that duck service because they know it's coming and they think, well, if I'm not at home, this can't happen. It can't move forward. That is not the case. So once the summons and complaint is served, you have to file those documents with the notice to quit and the summons and complaint prior to the hearing. So the notice to quit, the summons and complaint, and the affidavit of service, both the notice to quit and the summons and complaint must be filed with the court. Now, if we get to the point where that summons complaint has been filed and we have a hearing date and that tenant has not yet vacated, step 3 is actually a hearing. If the tenant does not show up, the landlord generally obtains a default judgment for eviction. If the tenant does show up, the landlord must present evidence supporting the eviction. And this will come in the form of testimony from the landlord or property manager, a copy of the lease and any supporting documents, ledger of past due balances, and photographs if that's an issue with regard to the alleged violation. The tenant has the opportunity to testify, but the tenant is prohibited from raising any counterclaims except offset to a demand made for damages or for the payment of rents or profits. The statute is very clear on this. This is very landlord friendly because once we get into an eviction situation, we don't want to be bringing up all of these collateral issues. The only thing is whether there's a lease, whether it's in breach, and whether the court can order the eviction. We're not going to go down a rabbit hole with regard to any other alleged violations. And eventually, after that hearing occurs, the judge will issue a ruling on eviction. Sometimes, and what will happen more often, is tenants will show up to court because they don't know what they're doing. And at least where we practice, the judges will usually explain to them, listen, tenant, I am very limited on what I can do here. Are you here because you just wanted to show up? Or are you here because you're actually contesting the eviction? And most of the time, I wouldn't say that. I would say about 50-50. The tenants are there not to contest, but they're there because they got a summons to be at a court proceeding. And so if that is the case, the hearing will go much quicker and much smoother. But if you get into a full-blown evidentiary hearing, that's when it can take longer and more time. So after that occurs, then you're going to get the decision from the court. If the court finds for the landlord, the court shall enter a judgment for immediate restitution of the property. If the tenant demonstrates that immediate restitution would be a substantial hardship, the court may grant tenant up to 5 days to vacate the property. However, if the eviction is for disturbing the peace, or immediate possession is granted. And of course, the tenant and the landlord can agree on additional time should they mutually agree while they're sitting there. And then a court will eventually issue the judgment for eviction based on the decision that they've made. It's completely up to you as the landlord how much time you want to give a tenant, but the law in North Dakota says that a court can only give 5 days. If you as the landlord want to give more than that, that is completely up to you, but the judge can only provide for 5 days. So you get to the point where you get a judgment for eviction, the 5 days has expired, and the tenant is still in the unit. So what do we do? At that point, you're going to be required to obtain a writ for eviction. And that is a writ that's issued by the county clerk of court's office, and it's executed by the county sheriff's department. And when I say executed, I mean delivered by and served upon the tenant by the county sheriff. So that's the very simple version. If you get to the point where that whole process goes through and everything has gone through, the law in North Dakota says that if you do have to vacate or someone does vacate the premises, there are specific provisions with regard to storing property and things of that nature. Sometimes that happens, sometimes it doesn't, but there is a monetary threshold that the state, or the statute does require as far as consideration of when you store those items and how long they have to be stored for. To talk about some special considerations, when it comes to landlord-tenant law, the most important thing that I can press upon you is do not engage in any self-help methods or remedies. Do not go out and change the locks. Do not remove any personal items, because doing so can make you responsible for treble damages. And treble damages is a fancy way of saying 3 times the amount of damages can be awarded by the court against a landlord that may act improperly. So if you have a situation where you have a tenant that's not paying rent, or they're unruly, or they're violating their lease, don't go change their locks and force them out. That is illegal and improper. You have to go through the necessary eviction process as set by statute. And of course, as we are in the way of the world nowadays, it is very important that you document and you are keeping track of your communication with the tenant. This would mean text, emails, notices, anything of that nature that talks about any issues or concerns that you're having with the tenant. It's important to make sure that you have those documented, because when you get into a court of law and you're disputing this or that, it is much better to make sure that you have all of that documentation supporting your position, because that can be detrimental. So you just want to make sure you have it, save it. If you have some management system that you typically use through your organization to keep track of all of that, it will be way better in the end if you have that and you're keeping track of all of that. Other special considerations, service animals. This is becoming a little bit more commonplace, but I'll just kind of give you the basics here. Service animals are not pets under the law, and the Federal Housing Administration does not require a service animal to be trained or certified. You must evaluate a request for a reasonable accommodation. And you have to ask yourself, does a person have a disability, and is there a disability related to the need for a service animal? You can also factor in the direct harm to others, and there's no pet deposit for a service animal. You can also ask for documentation if a disability is not readily apparent. So, for example, it could be a, like I said, a mental health type of related disability that wouldn't be something, for example, if someone was physically disabled in a wheelchair or something of that nature. So the parameters on service animals can be very touchy because it talks about state and some instances federal law. So if you have any sort of those types of issues that come up or present unique circumstances, I would always recommend that you chat with an attorney to be able to make sure that you're making a fully educated decision on how you're handling those types of situations, because like I said, those are becoming a little bit more commonplace. Usually tenants with, at least in my experience, tenants that actually have verifiable service animals are usually pretty good about presenting that documentation right away. If that person is struggling to do so and not providing it, there might be some indication that that documentation is lacking. But I don't want to say that as an overall generalization. It's up to you as the landlord to ask those questions to the extent that you legally can to be able to get that information. That was the very short versions of the presentation. So I will open it up for any questions that anyone has.
There is one question. I think Paige is having a hard time coming off of mute. What if the tenant is given a summons to court but does not show up? What happens?
In that situation, there is likely going to be a default judgment, and the court would basically be giving the landlord what they're asking for. So if the landlord is asking for a monetary judgment and they're asking for immediate possession of the premises, that is likely going to be what the court is going to enter as a judgment.
I think my mic's working now, Cheryl. Sorry.
It's working.
Okay. Christina, then another question, is there ever a time an immediate eviction can be given or warranted?
Yes, I think that to the extent that you have to go through the process, correct? I think that's the question.
Yeah, I believe so.
Okay. Well, I would say in that situation, let me get my video up here. Once you go through the process and you complete the statutory requirements for the summons, the complaint, and so forth, very often in these situations where you have no one that shows up, you get a default judgment. The court almost, I would say 90% of the time, or maybe even a little bit more, they grant immediate eviction. Where you're going to see a situation where the court might be a little hesitant to do that is when you've got a mom that shows up and she's got 3 kids with her, or, you know, something of that nature where, you know, it might present a little bit more of a challenge to have that person vacate right away. But it's not uncommon to have a court issue an immediate eviction. I mean, it also could be a situation too where the tenant is just behaving so terribly that by their own actions, the court imposes an immediate eviction. The 5 days is not required. Immediate possession can certainly be given, but the court can only go up to the 5 days. That is the maximum that the court can do.
Then there's another question. If a tenant does wish to dispute eviction, are they typically offered space to speak and or share any documentation they have to support their perspective?
That comes through the evidentiary portion of the hearing. So essentially what happens in a very simplified term is the tenant, excuse me, the landlord is the moving party. So anytime that you have a hearing, the moving party is the one that goes first. So the attorney for the landlord is going to basically present evidence in the form of testimony from the landlord, the property manager. They're going to probably submit a copy of the ledger. They're going to have a copy of the lease agreement. All of that stuff is going to be submitted. And the landlord will testify, and then the tenant has the ability to cross-examine the landlord. And once that happens, and the landlord has presented all of their evidence through testimony, then it switches sides, and then the tenant has the ability to then present evidence. And most of the time, tenants are pro se, and so it gets really clunky on how that works. But they have the ability to question and present evidence. The judges can give them a little bit of leniency because they're pro se, but that is when they have an opportunity to present evidence, present witnesses. Now, they can't sit there and make argument. If they want to take the stand and testify, they can. That's certainly allowable. Should they do so, the landlord's attorney has the ability to cross-examine them. And then when all of that is done, the court can ask questions if they have questions of either party. And eventually the court will make a decision based on the evidence presented.
Another good question is, can someone be evicted for damages if the damages were caused by a storm or a disaster, natural disaster, and a landlord refuses to make the repairs? Would a tenant be liable in this case?
Based on that example, I don't believe so. I mean, the tenant, if the property is damaged as a result of a natural disaster, I don't think that that's the tenant's fault in any way, shape, or form. Where you could have a situation where there's the tenant and the landlord might have to come up with some sort of mutual understanding about how this is going to move forward. But the landlord might have some sort of obligation to repair those premises for continued rental circumstances. I mean, you can't and you shouldn't be renting an inhabitable unit. So if you have a situation where you are renting to a tenant and like a tornado just comes through and tears off side of the building, that's not the tenant's fault. And the tenant shouldn't be responsible for that. The landlord, I think, is going to want to get that property repaired as soon as possible. But if there's significant damage that results in the uninhabitability of that property, that could cause issues for the landlord moving forward.
Okay, and here's another question for you. If somebody has paid the collection agency off to the collection agency it was turned over to, but the judgment is still showing unsatisfied on their background, who removes it or changes the status of the judgment as paid?
Sure. Doesn't happen very often that you see a satisfaction of a judgment like that. But if it were to happen, the best thing is for the landlord to file with the court a satisfaction of judgment. And that's just a simple one-page document that says the judgment has been satisfied, and it gets filed with the clerk's office so that it's no longer showing of record. And that's just the simplest way to do it.
They had stated they refused to.
The landlord refused to?
I believe so.
Yeah, that one you might have to seek some legal counsel to see what your remedies might be there as the tenant in that respect. But usually the appropriate situation is that a satisfaction is filed by the individual that holds the lien.
They said that the agency turned the property over to a different agency.
In that situation, if that new agency is a successor and a sign of that prior company, they might have the ability legally to sign that on their behalf. But again, you might have to, that's a question that probably requires a little bit more detailed analysis based on the specific facts of the scenario.
To follow up with the question, they also commented that once the unit was vacated and the eviction was paid off, the property management agency turned the property over to the other agency. So now they refuse to help remove the judgment they put on him and say it's no longer their problem.
Like I said, I think that's a situation where it's a very fact-specific scenario. And you might have a remedy, obviously, to seek to have that fixed or corrected, but that's probably where you're going to have to hire private legal counsel to deal with that specifically.
And then let's see here. So a question is, when someone stays with a tenant for an extended amount of time, if the landlord decides to evict, do they need to evict the person that is not on the lease too?
So if a tenant stays and for a longer period of time and there's another person in the unit.
Yep. If the landlord decides to evict, do they need to evict the person that is not on the lease too?
If the intent is that you want both people out of the unit, yes. The documents are usually set up so you have the individual's name, and then you have the line that says, and any person in possession. If you know that there is someone else living in that premise that is not on the lease, and you know that, I would also include them, depending on the circumstances, include them as a defendant. So there's no question that you are seeking to have that person removed as well.
And I don't see any more questions in the chat. I'll give it another second here to see. Oh, here is one. If a past due is showing up on someone's record while a potential landlord is running an application that doesn't belong to them, what can that person do?
I'm gonna probably not have the expertise to answer that. It's not necessarily a legal question. It's more of a question what you're going to be doing internally as far as background checking, I guess. So I don't think I'd be able to give a good answer on that one. I think that the standard protocol is that you follow whatever procedures you have in place as far as running background checks and doing those types of things. And sometimes that's a judgment call based on what management has in place for policy.
Okay, let's see here. They had a follow-up question in regards to the first question. What can the applicant do?
The applicant meaning the tenant?
I believe so. Yeah, while the potential landlord is running the application, what can the applicant do?
Well, I mean, I don't, like I said, I don't probably would say that to feel too comfortable answering that question from a tenant perspective. to be able to give you any sort of insight on that.
Mm-hmm. Once the judgment, this is a separate question. Once the judgment is made and the resident has not left, the process has been followed, at what point can landlord physically get the person out of the unit and take back possession?
So that's where the writ of eviction comes in. So the judgment is entered, and if they've gotten 5 days, what we typically tell our property managers to do is go check the unit after the time expires on the 5th day. If they're in the unit, call us, let us know so that we can get a writ of eviction so that the clerk can issue it. That writ is what the sheriff's office takes to physically remove them. You do not physically remove them. The sheriff's office does that. You can be on standby, you could be there, but you're not going into the unit and you're not physically removing anybody. It's the sheriff's office that does that. And so that's all done with and through that writ of eviction.
And then another question is, if a tenant moved here from out of state and has a disability, but had to go back for a yearly disability review and is now behind on rent because it is taking long to get funds approved, is that something we can let go until he is approved, or is it a breach of lease no matter what?
I think it's going to be based on what you as management decide. I mean, those are those unique circumstances where I think you have to be evaluated on a case-by-case basis. It's not based on that scenario. It's not a situation where this person is willfully dodging paying rent, or they're just a giant pain to deal with. If there's a legitimate reason why this person is struggling based on a medical issue, to me, that's a discretionary decision based with management to make that call. If it becomes a persistent issue and you're waiting months and months and months, maybe that's a different story. But, typically when it comes to a situation, if you ever found yourself in a situation where you're in a court and this person says, well, they kicked me out and I've got these reasons because I have a medical reason, and they were just completely unwilling to work with me, that's not a good look. So in that situation, it's not a bad idea to consider what options might be available to assist that tenant in some respect, at least initially, so that you are appearing that you're willing to work with them. If it becomes a situation where they're just not taking advantage of your ability to work with them, and it's just delaying it and becoming a thing and it's just taking forever, then at that point you might have to consider going a little bit more aggressively with either eviction and getting the court involved.
Okay. And another question, if a tenant goes to court and there was an agreement to lease term instead of evict, can the landlord still put an eviction on the tenant's record?
Did you say lease term rather than evict?
Yeah, I'm assuming that like terming out their lease and not having an eviction is what they're getting at.
Well, I would say that if you have an agreement with a tenant that says that you are not going to evict them, that you're going to term this out, then don't evict them, because then you're in breach of this settlement agreement that you may have. So be careful on what you're signing, and be careful what you're doing, because if you have signed something that says you're not going to evict them and you're not going after them for rent for whatever reason, then don't, because then you're going to be in breach of an agreement.
And then somebody asked, is a landlord required to hold the individual's items in the same unit for 30 days following an eviction judgment, or do they have the right to move them?
There's no statutory requirement that they be stored in the same unit. They just have to be stored. So if you have a storage unit, sometimes if there's a garage or something like that, you can certainly place those items there, but they don't have to be in that unit. I mean, obviously the goal would be to get the property out so then you can re-rent the unit, but you don't have to keep it in that same unit.
And then
I would advise, though, that if you are going, or if you are in a situation where you do have to store property, that you are notifying or sending a letter to the tenant saying, you know, based on this eviction, we have this property that has been retained in the unit. Just let you know, you have a certain amount of time frame in which to come get it. If you don't get it, here's what's going to happen with it. That way, if, you know, they ever came back to you and said, well, you didn't tell me that, you know, this is where my property was, you have a document that's sent via certified mail or some other mechanism via email that you can point to and say, yep, I did tell you this. You were notified. You chose not to do anything about it within the time frame. That's going to cover your bases as the landlord.
Okay. And then they did ask, are they liable for the replacement / responsibility if they do move the items and their damages?
Could it be possible? I assume if you know, if you had a, let's say there was some property and you know, it was majorly destroyed, I suppose, but that would be requiring the tenant to make that allegation toward the landlord. The statute says that if you don't come and get it within a certain time frame, and I think the time frame off the top of my head is 28 days, then the landlord can dispose of that as abandoned property. So that's why it's really important, in my opinion, to make sure that you're noticing these tenants to say, you've got this certain time frame to come get it. If you don't come get it, we're going to destroy it or we're going to dispose of it.
And that one is it for that question here. I don't see any more popping up.
Okay.
Christina, thank you so much for taking the time and sharing all of this information with us. It's great information and we really appreciate it.
No problem. Feel free to share my PowerPoint with anybody who wants it, and I'm always happy to help.
Okay, thank you so much.
You're welcome. Have a good day, everyone.
Thank you.